Phil Borton. Estate planning is so much more than planning for what happens after your death. So much more important is what happens before your death, in case you become incapacitated from chronic illness. What planning will you have done to help comfort your loved ones and those people who are there that have to deal with your incapacity? My guest today is Phil Levin. Phil is a trust and estate planning attorney with a Levin law firm. He's dedicated to helping his clients develop comprehensive estate plans designed to protect, preserve, and pass property intact to the right people at the proper time and in a tax-efficient manner. Welcome, Phil.
Thank you so much, Bill.
It's great to have you on the show.
It's a pleasure to be here.
So, Phil, I know when I mention long-term care planning to people, they think of nursing homes and insurance. But there's so much more to it than that. You look at it from the legal perspective. What do you think of, and what do you talk to clients about initially when you talk about long-term care and chronic illness planning?
When I talk with clients about estate planning and chronic illness planning, I believe it's very important to have a conversation with their family about what their desires and wishes are in the event they should suffer an illness, injury, incapacity, temporarily or permanently.
Now, when you talk about family, someone who's sitting with you to do this planning, if they're a baby boomer, then their family could include their parents and their adult children.
Absolutely. We work with the sandwich generation as well as the parents and children.
Mm-hmm. So when sitting down with them, what kinds of questions do you need to get answers to?
Well, I let them know from a high-level overview. Again, it's all about options and making sure they have a well-constructed long-term care plan to provide financial protection for them in the event they suffer an illness or incapacity, as well as an up-to-date estate plan to make sure that they control the distribution of their property and not the state.
Mm-hmm. So I know that there are a lot of people that just don't even know where to begin. A long-term care plan itself doesn't necessarily need to be drafted by an attorney. I know there are some documents that an attorney really needs to get involved with. LegalZoom just doesn't cut it. But before we start talking about the documents, again, let's talk a little bit more about the questions that you would expect a client to ask you or that you need to ask the client, such as where do they want to receive care if they need it, and who's involved in the process? Who are some of the parties that are involved?
Some of the key parties involved in a long-term care plan, as well as an estate plan, would be, of course, the client's estate planning attorney, their financial advisor, their accountant or CPA, and sometimes even their trust officer if they're interested in having assets distributed to their beneficiaries in the form of a trust rather than just outright.
Mm-hmm. Now, should some of these other advisors be involved in the planning process, or should they simply be informed of the plan after it's been completed?
I believe all the parties involved in the process should be together from the start so that nobody is feeling as though they were left back. Many times the attorney is the coordinator of the team, and often the financial advisor is the person who spearheads the ball down road, so to speak.
Well, generally speaking, from my own experience, my boomer clients don't just decide to get up one day and do a long-term care plan. It's like, should I get a colonoscopy today or a long-term care plan?
Sure. Yeah, most people don't want to deal with issues confronting mortality, especially their own. Mm-hmm. So I've had situations where clients have kept my card on the refrigerator for about 2 or 3 years, and then they call me when things start to go awry. It's called advanced planning for a reason, mm-hmm. and it's a good idea to sit down and have a coordinated strategy put in place with the legal, financial, and tax advisors well before somebody should suffer that illness, injury, or incapacity, because it's all, again, about options, and your options become much more limited if the person is ill or injured or unable to make decisions, because then the courts might have to take over in the form of a guardianship proceeding, which is much more restrictive rather than flexible.
And expensive.
And much more expensive to go through a guardianship proceeding where somebody has to be declared mm-hmm. judicially incompetent, because everybody in the country is presumed to be competent if that individual needs assistance in managing their personal, family, or financial affairs and healthcare decisions, mm-hmm. and is not able to do so. It's not a race to the bank or brokerage company by which child gets there first to control mom or dad's assets. A guardian has to be appointed if there is no agent appointed to make those type of decisions.
Mm-hmm. So when I think about most of my clients are boomers or slightly older, and they're still doing the initial planning for their long-term issues, getting a jump on it. Many of them are doing so because it's been fresh in their mind because they've had caregiving issues with in-laws or parents, and have in some cases found out what happened when there was no insurance present or when there were no legal documents present. You can't manage the affairs of someone who's incapacitated mentally or physically if you don't have the legal authority to do so, right?
That is crucial. And it's very unfortunate, Bill, I should have mentioned it earlier, that many people take better care of their houses, cars, boats, and tangible property by insuring those assets, those physical assets, but they never step back and think about, what about insuring myself in the event I become incapacitated or I can't work and I'm disabled temporarily or permanently, and how will that affect my family?
So Phil, if you're 60 or 65 years old and you have parents that are 20 or 25 years older and they're frail and maybe starting to get forgetful, I think it's pretty important that they get in to see you and start doing some document drafting so that when the parents get a little further down that road towards the end, that their adult child or children will be able to help manage their affairs, right?
Absolutely.
And then once the dust settles on that process, then it's time to take care of their own affairs.
Yes, indeed.
So if a boomer child comes to you and they're concerned about a parent, where do you go with that?
Well, very times it's the boomer child that comes in after they've taken mom or dad to a potential nursing home or assisted living facility and found out in states like New Jersey and Pennsylvania that the average cost of care on a daily basis is about $330 per day, which is of course over $9,000 per month, and those expenses are not covered by Medicare. So without a well-constructed long-term care plan funded by insurance, very often the family has to pay dollar for dollar out of pocket for those expenses that could go on for not just a matter of weeks or months, but we often see this happening for a matter of many years, often washing out a good portion of the client's estate.
Or washing it out entirely.
Almost entirely, it happens in many cases.
And in many cases, they wanted to leave all that legacy to their kids, and now they end up paying it for caregiving.
Absolutely. I like to say that a long-term care policy does put a trap door under the client's assets to protect them from being lost through nursing home and assisted living expenses that very often are not covered by other sources of assets that the client has.
Mm-hmm. So, Phil, when you sit down with a client, I know there are a number of documents that need to be drafted, and a lot of thought needs to go into some of this. Some of them are a little bit more cut and dried. Some of them are far more involved, particularly you think about a last will and testament, and there's lots more to it than just, who gets my money when I die. What I really like to do is get into talking a little bit more about each of these documents and what they're for and why they're important. We're going to do that, though, after we take a short commercial break for a word from our sponsor. This is Bill Borton. I'll be back with more Phil Levin and Live Better Longer after a word from our sponsor.
RVN TV is a platform for people of any industry to share their story. Over 285,000 viewers are tuning in to RVN TV shows monthly. We guarantee a great experience that you'll be sharing with everyone you know while increasing your personal and company's brand awareness. But what is your brand? According to Forbes, it's a combination of your logo, your product, your design and feel, and your personality. Did you know that aside from being a guest, we offer even more opportunity to boost your brand? Adding your company logo and website on screen during your interview will allow viewers to recognize your brand instantly. Incorporating images and video clips is another great way to showcase your product during your live segment. Let viewers see how good you really are. And most importantly, there's you and your interview. For less than the cost of a newspaper, direct mail, or a magazine ad, You can leave our studio and within 48 hours have a permanent digital copy of your live segment to link to your social media, embed into your company website, or use in email marketing. Investing in your brand is so very important, and we can't wait to have you as a guest.
Welcome back to Live Better Longer. I'm your host, Bill Borton, here with Phil Levin from the Levin Law Firm. Phil, we know, as we touched on briefly, there's a lot of legal documents that are involved in planning for long-term care or incapacity. First of all, client, everybody knows you need a will. And I don't want to spend too much time on that because that really talks about your assets after you pass. But are there any aspects of a will that are involved with long-term care planning?
Absolutely. Before getting into some of the most important documents in the long-term care planning arena, a will is a cornerstone of the estate plan. It does appoint your executor and does decide how and when your beneficiaries would ultimately receive your property. It sounds very easy, but over 65% of Americans pass away without having an up-to-date will, and intestacy law controls how their property is distributed, as well as who petitions the court in the county where the decedent resided in order to become designated to take over the control, management, and distribution of property. So it's a very restrictive proceeding, and one that can be completely avoided by having an up-to-date will.
Okay, so now that again applies when you are deceased. Prior to being deceased, you may be chronically ill or incapacitated and need a number of things to happen. I hear about powers of attorney. Touch on that for a moment.
Sure. One of the most important documents, and I call the living documents, are the durable financial power of attorney. Durable simply means that in the event that our client becomes ill, injured, or incapacitated, the document is still legally operative, avoiding a guardianship proceeding because the client was able to designate who they wanted to serve as their agent in the event of an illness or injury.
So a person who is conferred with the power of attorney can write checks, pay bills, make financial decisions on how to spend the money for care, correct?
Absolutely. Again, it does avoid having a member of the family petition the surrogate's court or orphan's court, depending upon the state, to have a judge decide which family member is appointed. And very often, a judge might appoint somebody completely outside the family unit who our clients don't even know, which is not something that's very palatable to most of our clients, is having somebody else step in who's unrelated to them make financial or healthcare decisions.
So now, talking about healthcare decisions, when it comes to non-financial healthcare, you know, what should be done for you if you're incapacitated? What document becomes involved with that?
Sure. In addition to a financial power of attorney that controls decision making with respect to bank accounts, brokerage accounts, insurance policies, we always make sure our clients have an up-to-date advanced medical directive and healthcare power of attorney. The healthcare power of attorney designates your agent as well as a backup agent to make, as the name implies, healthcare decisions in order to avoid a guardianship proceeding that can save your life. Many of our clients think that the healthcare power of attorney is only about pulling the plug or ending life. It's quite the opposite. It's a critical, vitally important legal document that authorizes your agent to make decisions that can save your life by authorizing them with the authority to communicate with healthcare providers.
Or what kind of care setting you might be dealing with.
Exactly. Where do you want to live? Assisted living facility, nursing home, or staying at home. A lot of our clients want to age in place. If the client does not make their wishes clear to their family members and then is unable to speak because of a stroke or heart attack or other physical or emotional illness or a combination of the both, it makes it very, very difficult for the clients and puts an undue amount of stress on family members that can be completely avoided.
And in many cases, if you have 2 or more children, they tend to not always agree on what's best for mom or dad. And without mom or dad having made those decisions in advance and having that been communicated to the children and having one of them appointed as the primary healthcare power of attorney, you can have families that are in chaos and get torn apart forever.
I've seen that happen many times. It's very unfortunate, Bill, that family fallouts often occur not over the distribution of assets, which often are very clear under the terms of a will or under a trust or even under intestate law if somebody dies without an estate plan. But we don't want to see families fall apart and get into a situation where they're not talking with each other for days, months, or years because each person has their own recollection of what mom or dad actually wanted. We see this happen very often when tangible property is divided among family members as a result of death. As I mentioned, children often don't fight about $1 million at a brokerage account and how that's divided because that's very clear. They often argue or have fallouts over tangible personal property. So that's why we always include a tangible property memorandum so our clients can decide how their personal property can be distributed in the event they should pass away, which again avoids the family fallouts.
So again, I come back to what I always say to my clients and to people who watch the show, and that is it all begins with what I call the conversation. And the conversation needs to be had between the adult child or children and the parent or parents, while the parents are still cognitively able to have that conversation. And then once they start to really put some meat on the bone about what mom or dad really wants and what the kids think they'll be able to deliver in the way of care coordination, hopefully not caregiving, then it's time to then come and see you and then have the conversation where you then add the legal component and start talking about documents.
Absolutely, and we do have a checklist that we can provide to prospective clients that deal with the long-term care planning process and, of course, their estate planning wishes.
Wonderful. So one more document I think that you mentioned is called a HIPAA waiver?
HIPAA waiver authorization is a very short but a very powerful document because today doctors, hospitals, and medical care providers do not want to and are not able to legally communicate even with a spouse or family members such as children unless their names are on a HIPAA waiver. That provides the legal authority for doctors, hospitals, and medical care providers to communicate not decision making, but condition of a particular individual or client to the family members.
So without the HIPAA waiver, I go across the country to see my mom in a nursing home. My dad's already passed away. Mom's in a nursing home. She can't talk to me at the moment, or if she can, she's not making much sense. And I go to the doctor and I say, Doc, what's going on with mom? He may not be able to tell me?
He might not be able to tell you is absolutely correct, and even worse than that, we see situations where college students who are 18 or 19 years old, which is past the age of majority, wind up having different issues occur while they're in school, especially that first year of college. And when they go to hospitals or infirmaries, unless the parents are on the HIPAA waiver, very often it makes it very difficult to communicate vital information to the parents, even about their own children if they're over age 18. So it's not just about the grandparents or the individuals in their 70s or 80s or older, but it's also about children who are over the age of 18.
So many things to consider. You know, Phil, you and I have known each other for a number of years, and I know that you teach, and I know that you speak about this as well. I think our viewers are probably getting the idea that you really know what you're doing when it comes to this. And it's not just about documents, but you've got so much life experience around this planning so I'm just imagining that a number of our viewers, if they haven't done this kind of planning already, are going to want to get in touch with you. What's the easiest way for them to do that?
Sure, the easiest way to get in touch with us is by contacting our office directly at 610-977-2443, or by jumping onto our website at www.levinlawyer.com. Individuals can also send us an email if they have any questions or would like to discuss their particular situation at info@levinlawyer.com. So those are 3 or 4 ways to easily get in contact with us, and we're very responsive in terms of getting back together and in touch with prospective clients.
And you have offices around the Philadelphia area. Do you practice in Pennsylvania and New Jersey?
Pennsylvania, New Jersey, and Malton, Radnor, Plymouth Meeting, Bala Cynwyd, and Philadelphia.
Very good. Wonderful. Well, Phil, it's been great having you on the show. And in the remaining moment or two that we have, do you have any final words of wisdom for our viewers?
Well, I like to say that it's very important to make sure that a personal tragedy such as an illness, injury, incapacity, or death does not become a financial disaster and a real burden for the family. You can avoid those problems from occurring simply by doing the proper advanced planning, sitting down with your financial advisor, your accountant, and your estate planning attorney to make sure the appropriate legal documents are put in place and the appropriate insurance is put in place in order to shift that risk to a third party in terms of providing financial protection for yourself and your family.
Good advice, Phil. So just like a long-term care policy is insurance against the possible or likely future need for funding for long-term care, investing in the legal documents that can make this work at some point in the future is insurance of a different kind.
Absolutely.
And insurance that should not be overlooked.
I would agree.
Phil, it's been a pleasure having you on the show. Our viewers are much better informed now, I think, as a result of your counsel and wisdom. It's been terrific. Thank you so much, Phil.
Thank you, Bill.
This is Bill Borton. We'll be back next Tuesday at RVN TV at 11 a.m. with more Live Better Longer. Thank you. Have a great week.